All right, everyone. Thank you so much for joining us today, taking time out of your Thursday to join us for our educational training. My name is Natalie Pardo. I'm the program manager at Latino Built. And today we have Javier from Hernandez and Associates, who will be talking to us a little bit more about protecting your construction business with enforceable contracts. And so before we do dive in, I just have a couple of reminders. We are organization that gives you credit for training for your CCB continuing education credits. So if you are someone that wants credits, let us know. If you already registered for this event, I have a lot of information down, but if you just joined via the Zoom link I sent out about an hour ago, please just send me an email and we can get you credit for the class today. As I mentioned, this presentation will be recorded and will be available on our YouTube channel in the next few days. You'll get a message once it's posted. You'll want to keep your microphone on mute for the entirety of the presentation. We'll have the opportunity to take questions throughout. So if at that point you want to unmute yourself, you're welcome to. Otherwise, the chat will be open for all questions that you have for our presenter. If Zoom works for me, which fingers crossed, we will have a short survey at the end of the presentation as well for you to let us know what you thought about the event. So with that, I don't want to take too much time. I want to introduce our presenter for today's presentation. We have Javier Spyker from Hernandez and Associates.
Hi, let me see. When I go full screen, I can't see our screen. My name's Javier. I'm an attorney with Hernandez and Associates. I've been practicing for about 8 years. I practice concerns mainly small businesses, family estates, and family estate planning matters. So basically my job is to, as I see it, is to keep wealth into my clients' pockets, and the more successful they are, the more successful I am. And so we're going to spend some time on discussing contractor liens, and hopefully it's informative and insightful. If you guys have any questions at any time, go ahead and put it in the chat or unmute, or however you want to get your question in, and that way we don't move too fast or go over something that's not explained. So I'll just jump right in with, okay, let me go Zoom, share screen, host participant disabled screen sharing.
And I just gave you access.
Okay, there we go. All right, share, and from the beginning. Okay, that's me, that's my firm. The Spanish presentation, we'll have some help from Alejandra. She'll help us out in Spanish. So during this presentation, I'm going to explain what a construction lien is, who can record a lien, the eligibility requirements for a general contractor, preliminary notice requirements, the property owner's rights, and how we recover debts owed to a general contractor. We'll summarize general contractor status, and then we'll review the tools to recover debt. And finally, then we'll really dive into the preliminary notices and the types of notices for the subcontractor. So a lien, to simplify it, a lien is a claim against a piece of property against the homeowner, and that lien is notice to all other parties that we have a legal interest against the real estate. So that lien is powerful because it's recorded against the title, it's recorded at the county level, and those property liens prevent the homeowner or the property owner from wiggling out and not settling the debt owed. Construction lien is a claim made by a property owner or against the property owner by a contractor or subcontractor is not paid for that work. In certain cases, we can even foreclose against the property and force a sale against the property with a validly recorded lien. And we'll talk more about how to validly record a lien. So we're going to click through the Spanish slides, and we'll focus on the English slides for this presentation. Let's see if I can grab that. So who can record a lien? Anybody in the construction business or the materials business has a right to collect payment from the property if they aren't paid. To record a lien, you have to have either a CCB license, or you can be a subcontractor who's owed by the general. So some of you working on bigger projects where you're a subcontractor to a general, you can also record a lien. And that's a nice benefit of being a contractor. General contractor is somebody who's directly contracted with the property owner, and a subcontractor is somebody who is contracted with the general. So these are roofing, drywall, plumbing, electrical, painting, window, all kinds of different subs out there. You know, in some cases, property owners are not directly contracting with the subs. In some cases they are. So kind of understanding that relationship and understanding where your business falls along the tree of contracting will help you to understand your rights. And so to be eligible to file a lien, you have to have a proper CCB license, and you have to provide proper written contracts that require the necessary information. So written contracts are not required below a $2,000 service fee, but I wouldn't recommend doing work without a contract. The contract has to provide the preliminary notices, and you have to keep signed copies of those notices. So an unsigned contract or a contract that does not have proof of delivery of the notice is not going to be good enough or effective enough to attach the lien. And my contracts, the way they're built, the homeowner is initialing that they received the notices on the contract. So you have initials that they've received the notice, and then you have the notices themselves that are also signed. With those two things, now we can record our lien if necessary. So the notice, it's a legal term, but it's basically a written paper that's explaining everybody's rights and the facts of that you guys have a legal right to lien. So I see a lot of contracts. I get a lot of phone calls from contractors saying they're having a hard time getting paid. And my first question is did you give notice? And there's usually a silent pause, and the contractor says, well, what is notice? And I said, well, there's 3 documents in general that we have to give notice on, and with notice we can then go ahead and file our lien. So without notice, you don't have the ability to file a lien, and without proof of notice, you're not going to be able to file that lien either. So the 3 notices are the consumer protection notice, the notice of procedure, and information to the owner about the construction liens. So you can get in trouble sometimes if you have to go to CCB arbitration, or if you have to really fight it out if you didn't give the proper notices. So giving the notices gives you a level of protection, and it's required in some cases. So let's discuss the consumer protection notice. So these are statutory notices created by law, created by legislature, put in place by the CCB board. So you'll see here, this is an example of the notice. You see it's described by the law ORS 701.330. And we're explaining, this explains to the consumer their rights. It explains that they should be working with the licensed contractor. It gives them information about what kind of bond insurance should be provided or disclosed. And it also educates the consumer on the type of steps they should be taking to see the project through. So it talks about gathering bids, dealing with contracts, getting their contracts in writing, putting change orders in writing, the level of detail that's required in a contract, and what they need to understand about that contract. There's also going to be some information about how the job's going to get paid for, and any type of warranties on new residential construction. And it gives them the phone number to the CCB. So this is your first notice. And you see here, we have the version that has a spot for the contractor's signature and the property owner's signature. You would collect a signature on the bottom of that document. And you're actually going to collect a signature on each document. So that's the first notice you have to give if you want to be able to file a lien. The second notice you have to give is the notice of procedure regarding arbitration and lawsuits. So this explains what the homeowner must do before beginning an arbitration or court action against a contractor. It's interesting that this notice is actually telling the homeowner how to argue or deliver or debate with the contractor to get something repaired or made right. So you guys probably know the CCB offers a mediation program, and they will come out and mediate issues between homeowners and contractors. And so this notice is designed to give the homeowner that information, so that they can go to the CCB and seek out the help they need for getting issues dealt with between the contractor. So that's the second notice. The third notice is specifically about your ability to issue a lien. So the law provides this notice to inform the homeowner that you have a right to make a construction lien, and that right flows through properly providing these notices. So if you haven't been paid and you have these notices, we can file a lien and we can get you paid. Without the notices, it's a long uphill battle to try and get the contractor paid. So you contractors have to understand that, you know, the risk is all on you if you're not getting paid, or if you're not getting paid up front. And depending on the size of the job, you know, a $2,000 remodel versus a $20,000 remodel, you're going to have more risk, more labor, and more materials in that $20,000 job. And so you might think about getting your lien notices in place in case you don't get paid on that bigger job. On a little job, maybe you can be less informal, but you know, during the crash of 08 and 09, there was a lot of subcontractors that got burned because they were doing a lot of work and they didn't have their lien documentation in place. And so a lot of subcontractors lost, especially. So this is the third notice. It goes to the owner and it tells them what they need to do to protect themselves against the lien. So a lot of these are built to both protect the homeowner and the contractor and make sure everybody understands their rights. So these notices, these 3 notices must be given on or before the contract is signed. So you can't get halfway through the project and think that you can cure and get these liens, get these notices out on the last day when you have that funny feeling you're not going to get paid. So you need these signed and in your possession before you start the job. And then you need to keep the original as proof that you gave notice to the owner. So if you lose the originals or you don't have them, you're not gonna be successful in getting paid. The only exception is if the homeowner is a licensed contractor, then you can get away with not giving the notices. But it's very rare that you would be contracting for another contractor to do work on their house. So who has to receive the notice? The owner or the agent of the owner. So the homeowner, or if their son or their daughter's running the project, or if they're general contractor, whoever's running the project, they need the one to sign those notices and give those back to you. The first purchaser of the property constructed by the contractor and sold before or within 75 days after completion of construction. So that's a new home builder scenario, that second sentence there. So it has to do with the warranty and completion of construction. The first property owner is entitled to receive the lien notices. Okay, so potential actions by property owners after receiving a preliminary lien notice. So when a property owner who hasn't paid gets one of these notices that you're going to put a lien on their house, they typically start writing checks because they don't know what the lien is, but they know it's not good. And so sometimes they try to write joint checks, or they try to write checks that are unsigned. You want a single check issued in your name. You don't want a joint check because that'll not get, that the bank won't take it. Property owners sometimes ask subcontractors to take a waiver or release before signing, making payment. At that time, they've already probably consulted an attorney. And if you release your lien or you sign a waiver, you're giving up your rights. So you're into attorney land at that point if you're considering waiving or releasing your right to lien. Property owners can send letters. They can demand that you tell them all the materials and equipment you use. They can ask for a description of the labor, a statement of the contractual basis. And so basically the property owners can demand more information if they think they didn't get the value or what was contracted for. But you have to respond to a written letter requesting more information about your contract. So you can't just let that letter slide by. If there's a request in writing for more information, you have to be responsive to that within 15 days. Oh,
We have a question.
I got a sorry, I got a really quick question. If you gave the proper lien notice and they signed the contract for $50,000, and then you complete the job, and then you leave, and you send them a bill for $50,000, how can they request a full accounting of your services at that point?
Well, the law gives them that right to try to clear it up or get verification that they got what they bargained for. Some of the contracts I've seen are just written so vague that it's hard to tell what the actual deal was. So like a house painting contract, the guy's like, I'll paint your house, you know, and an estimate of how much square footage on the house, but you know, did that square footage include the under the eaves? Did it include trim work? So you head that off by writing a good contract to start with. So $50,000 of electrical services to include a panel and this many circuits and this many outlets. You know, numbers are always good in those contracts rather than I'll wire up your whole house and it's 50 grand. So that's kind of how you protect yourself. But the property owner can always demand the letter, and that's just incentive for you guys to keep good track of materials and hours on your job. You don't have to, yeah, you might have to recreate it, but you got 15 days to do it. Okay. So if you're a general and you want to recover a debt owed, you can file the lien claim. So that's filed at the county level at their records division. We'll file the lien directly against the property records. You can file the claim in small claims court, which is an informal process. Lawyers aren't allowed in small claims courts, but you could basically file your claim in small claims for $7,500 or less, and you'll show up and the homeowners show up and you'll have a little powwow and a judge will decide who's going to win on that. You can file it in state or circuit court, which is your county level courts. And at that point, you're paying for a lawyer to do that. The other side's paying for a lawyer to defend that, and you're on a long road to recovery. So those circuit court claims could take a year and a half to prosecute. In COVID, who knows how long it takes, because things are running slow. One thing to be aware of is your recovery is limited to the value of the contract. So that's not going to help you cover your legal fees or cover your other fees associated with filing your lien claim. So you're just trying to recover the amount of your contract. Doesn't include attorney's fees or anything above and beyond what you're owed. So contractors tend to eat the attorney's fees on these deals, but a properly noticed contract and lien claim is usually enough motivation to get the homeowner to the table and write the check without going to court. Because once you put that black eye on their title, they have no way to get it off, and they know you can foreclose on them. So you put all your protection and your efforts up front by getting properly executed contracts. And then on the back end, if you have any problems, you have the leverage in the situation. You're the one with the right to lien. So you don't have to, sure.
Can your lien collect interest?
Oh, that's a good question. I don't believe so, unless your contract states there's interest running in the contract. And I have seen some contractors that they sort of finance the project and they add, 6% interest onto the deal. But I've never actually fought one of those out before. So if it's 10%, 25% of the cost due 30 days after starting, and then 6% interest running on that 25% until paid, I think that would be valid. But I've never had to fight it out, so I'm not sure. But that's a good it's a good idea if you're going in for if you're basically financing the materials and financing the deal, that cost is running against you. So something I would dive in deeper if I had a client that wanted to know. Okay, let's keep going. So the procedure to file the lien is, like I said, recorded at the county in the recording officer where the construction occurred or where the house is located. So within 20 days after filing it, we're going to send a written notice to the owner and also to the bank who owns that house, who's also on deed. And so most people with a mortgage on their house, that mortgage contract tells them they can't also attach other debts to the house. Because if Wells Fargo's the home lender, they want to get paid back before anybody with a lien or any other secondary kind of debtor that attaches to the property. So you have to also attach a copy of the lien with the notice. So if communications completely break down with you and the property owner and they're not talking to you and they're not taking your call anymore, they just figure they're not going to pay you, they're going to get this letter that you've already filed your lien. Then they're going to start talking to you again all of a sudden because now you have a lien recorded against their property, and they're going to go talk to their lawyer probably, and the lawyer is going to say, well, they got you, they gave you notices, they filed their lien, it's properly recorded, I recommend you pay this and not waste money on me. And that gets the homeowner or the property owner thinking about paying you. So for your timeline as a lien holder is you have 75 days after completing the construction or not working on the project anymore to file the lien. So, if maybe 1 month goes by and you still haven't reached a resolution, 2 months go by, you haven't reached resolution and gotten paid on your work, and if you have the proper notices, then you got about 15 days to get it filed after 2 months. So if you let 80 days go by, you can no longer file your lien. So there's a time limitation that will keep you, will bar your claim. So that's painful, and that can sneak up real quick because the weeks pass on, and I don't even know what I was doing 75 days ago, or the files I was working on. But hopefully I don't have any that have gone unpaid that long. Okay. So what happens after lien is filed and recorded? So either you get paid by the property owner, or you have to start a court action and you have to foreclose. So there's a whole legal procedure of foreclosing the lien. And foreclosure means we're going to force a sale of your home, of the property. So there's a lot of notices that go out. There's service of the complaint and a lot of procedure in foreclosure. You're basically acting like a bank in foreclosing, and you're going to force a sale of their property. and you might even have to have a sheriff come remove them from the property. So it gets real messy. But 120 days after you record, you have to foreclose on the lien. So you can't just file the lien and let it hang out there. You have to pursue it. Then there's also a notice of intent to foreclose 10 days prior. So on the other end of that, if the lien's been satisfied by full or partial payment, then you have to remove the lien or certify that you've been paid off. And so the responsibilities go both ways. The property owner is responsible to pay you. If not, you can put the lien on them. If you do put the lien on them, then you have 120 days to enforce that lien. And if you've been enforcing the lien or they paid off the lien, then you have to give notice in the court and satisfy that lien and remove that lien from the property, or else they can sue you. So most important things, be properly licensed, use a good written contract, give those required notices and have signed proof that you gave the notices, and then file within 75 days, either of the last day labor was provided or materials furnished. Sometimes, if you know it's going to take you time to get paid on a contract, and it might take you more than 75 days to figure that out, then it would be a good idea to find a reason to go back to the property and to perform some kind of service. Like, okay, we're going to go back and recaulk this, little hole or something of that nature, because that will reset the calendar. It'll move you 75 days because we're talking about 75 days from the last day labor was provided. So you can push the time scale further down the road if you go provide labor down, say you finish the project mainly at the end of July. If you want to get more time, you could go back at 30 days in August, do some caulking or some light labor, and then that sets your 75-day clock out a little bit further. And it could be for reasons like you want to protect your ability to lien, but you also want to give the homeowner a little more time to get his money together or what have you. So that's a inside secret trick there. Okay. What can your subcontractor do to recover the debt owed by the general? So a sub can always file a complaint against the general with the CCB within 1 year. We can always take the general to court as a sub who worked for the general and didn't get paid. Or again, you file that lien claim against the owner within 75 days. So that'll really get the owner calling the general saying, why do I have a lien against my house? You're the general, you take care of this. So if you go ahead.
You're on mute, Eric.
So how do they receive notice in that circumstance? The owner?
The property owner. So they're going to get the same notice that they would have got in the other case, where you're just giving them notice of right to lien. It's a written document, standard format, and delivered in writing. And you're probably going to send it both to the general and to the property owner at that point.
And who signs that? The owner and the general?
No, so you're enforcing the lien, you're sending the right to lien. It's coming from your office. And they don't have to sign it. You just have to have proof that you gave it to them, gave them notice. So we're gonna send certified letters, certified sign, signature letters, and they're gonna sign for it. And then the clock's gonna start ticking. So one good thing about this is that you can get paid out of the general's bond and make a claim directly against the contractor's bond. But those bond payments are limited, to a real low amount. I think that has to do with the insurance companies and their ability to influence the laws in their favor. Because the insurance companies, they don't want to pay out on any of these bonds. They just want to accept premiums. So, but when the bond payment's insufficient, we're going to file that CCB order with the county clerk, and it's going to have the same effect as a court judgment. So let's say you file a complaint against the general and you're within a year, and you've also noticed the property owner, and then the CCB says, okay, what's going on? And we're going to have a hearing, or we're going to have some kind of administrative ruling on the, they're going to play umpire in this case. And that's going to be cheaper for you guys because you're not going to be paying for attorneys and court fees. You're just going to be using the CCB and showing up as a business owner and saying, hey, here's the facts. Here's what I did. Here's my contract. I want to get paid. And if the CCB referee agrees with you, now you got a piece of paper and you take it straight down to the court and you file it. And then you have the ability to foreclose and get paid. So the CCB process is going to save you money and time in that regard. But this is subs against generals, and it doesn't always apply.
Sorry, I got one more question.
Go for it.
So you send out notice to you get contracted to do $50,000 to bring in shell power to a new building or a tenant improvement. You bring in the power, $25,000. You're going along. You sent your notice to the owner and the general, and you come back in a month and you notice that there was a change in ownership of the building. Like the owner, started working and then got to a certain point and then just sold the building to somebody else. How do you get paid in that circumstance if they don't want to get paid, if they don't want to pay?
So you're gonna run that lien. You're gonna run and record that lien against the new owner. I mean, we're recording against the property. We don't really care who the owner is.
I was just talking about the notice, serving notice.
Oh, so you come back, you find out that there's a new owner. You call up your attorney or you call up the records division and you figure out who's the new owner, and there's an address on file where those tax payments are going, and we'll get that address and we'll serve them notice that way. Because those are public records.
Yeah, I got you. If you weren't aware, I mean, as a subcontractor, or maybe even a general contractor, you might not even know there's a change in ownership. So trying to serve notice, I don't know. Yeah, especially if you've got a crew going out there. So, okay.
Yeah, once those little hairs on the back of your neck start to stand up, it's maybe time to do a little little digging and getting your ducks in a row. If you feel like there's some funny business going on. There's something in the chat. Don't be sorry, Eric. Okay. So yeah, we like the CCB in this process, especially subcontractors versus general contractors. The CCB is going to be very helpful for you and save you money as opposed to an attorney. Okay. What a preliminary notice should a subcontractor provide to protect their lien rights? Okay, notice of a right to lien. It's basically statutory paper. I think I showed you an example earlier. There's no notice required on the commercial property. So Eric, your question about the, determining whether it's a commercial property or residential property, that's going to change the rules a little bit. Okay, notice of a right to lien. This is an example here on the left side. It informs homeowner that a lien may be placed on their property. It has to be within 8 working days of the start date for the work or the delivery of the materials. So within 8 days, pretty fast. Right to lien, you provide it to the owner, the agent, the mortgage lender, or anybody else with a tie to the property. So we can real easily look up and see if there's like 4 banks on a property or a multi-development kind of thing. You might have the county on there. I'd like to send a lien notice to the county here. Anybody I can ruffle their feathers, I want to send that notice to, because it's going to get things moving. Notice of the right to liens considered given when it's personally delivered, like in hand or mailed. If we mail, we're going to do certified mail with return receipt, and we're going to save that evidence that we mailed it out. Most important things to do when we're filing a residential lien is send a notice of right to lien or deliver it in person and get it out quick. So my best practice, I don't even wait. I deliver all 3 notices at the beginning, and I know all the paperwork's in place before we even step foot on the property. And the property owner might push back, hey, what's this notice of right to lien? Yeah, standard paperwork. I put them out with every job I do, and that's how I make sure I get paid. But there are savvy homeowners out there that are waiting for a contractor to come and blow through that notice of right to lien thing. And in their mind, they say, aha, I don't have to pay this. He can't file a lien. He's got to sue me to get paid. And I know he's not going to sue me because it's only $15,000. And to hire a lawyer is going to be $10,000 or $15,000. So I got this guy. And, they set the trap, and we walked into it. And I think that's all I got. If there's questions or other things you guys want to chat about, happy to do so.
Yeah, I open it up for any questions. I know I have 2, if nobody else has any.
Hey, Javier, I just had a question. For us, we don't have templates available. Sounds like there's templates available. Is there such a digital service, something to automate the process, something you can pay into, say it's, I don't know, $19.99 a month, something we punch in a couple of addresses, we punch in who the GC is, whatever, we hit enter, and the thing auto generates a document that, I don't know, to go to where it needs to go. And that way we don't miss a stamp, we don't miss a line, we don't miss a deadline. Is there such a service?
I think the lawyers would get mad if there was such a service.
I know.
You're running Javier out of business.
Yeah.
$360 an hour, but it's gotta be a service, something of hell,
Right. So we build contracts for contractors all the time. We just review them, and then we put the little notices in where we want them to initial that they received the notices, and the notices are all statutory. So we get those directly from the law. We pull those out of the law and from the state, and they update from time to time, but they don't update every 3 months. So if you had your contracts reviewed once a year or every 2 years, that's money well spent, because the type of work and the amount of work you guys are running through, it's always risk versus reward. And I had somebody in here yesterday arguing about an easement that they got paid $40,000 on, an easement. And they didn't want to pay, they didn't want to go further in the attorney process by saying, look, what you're risking is $40,000 in damage to your property. And maybe it's worth $1,000 or $2,000 for some insurance on that $40,000 and maybe your foundation washing away. And, some people will do the math and say, yeah, I think that's money well spent. And some people will say, my contracts are fine. I'm sure I'll get paid. But don't call me at 7 o'clock at night on Friday trying to get me to file a lien notice. So if you go to the CCB regs and you do your research and just read through those handbooks, you'll come to the same conclusion that I've presented here. The CCB language is pretty accessible, and as business owners, that's a good investment of your time, is just reviewing reviewing the rules of the road. And if you don't want to review the rules of the road, then you pay somebody like me to shortcut it for you and get you where you need to be.
Okay, I have a question. So let's just say, I know you said at the beginning, you have to do this before you start the job, or when the contract is being signed. Let's say someone who's barely starting off realizes they did not give the forms. Can they, they obviously can't backtrack and, legally hand them, and they're still protected by it. What could they do if they find themselves in that kind of situation?
I would find a reason to execute a change order, and I would put my notices in on my change order and see if that gives me some coverage. It probably won't, but it might be enough insurance or kind of leverage in the contract to let the property owner know that, hey, this guy's playing by the rules. And a lot of subs get burned in the change order general contractor land. And it's a tough place to be. It's a tough place to fight. You're going against seasoned veterans, and you're new and you're excited and you're just trying to get the job and happy to have the job. But I would think about trying to get your notices in. Now, you don't have to have these notices in the commercial context. So, but in a residential context, you need the notices. So I would try to get a change order and get a contract revision in there. Or just quit putting out materials and labor on your own dime and get a payment in the meantime.
Okay, thank you. David, Eric, any other questions? Okay, I think that's it. All right, well, let me share my screen. And we'll continue with this. As for the presentation information, Javier has wrapped up, which thank you so much, Javier, for taking time out of your Thursday to be with us today and answering these questions. All the information you shared is very vital. And it's out there, but it's always great to have someone explain the process a little better for everyone. If you think of a question that you're like, dang, I didn't have a chance to ask Javier today, Javier is one of our contacts with our network, so we can always make sure to forward off your question and get an answer for you. So with that, again, I'm hoping my poll works for me. So I'm going to launch a poll. Just let me know what you thought about the event. Just 3 short questions. It's anonymous, so feel free to tell me what you think. I'm going to let the poll continue while I continue. Oh, relaunching poll. Did anybody get to? Nope. Relaunching poll. I don't think I can click out. So I'm just going to give it like 10 seconds, 30 seconds for you to answer. But I do have a couple more announcements. We have some events coming up, some exciting ones. Hopefully you've been reading my emails to you about what's coming up. Some of the exciting ones that we have, for example, next week we will be hosting with Energy Trust of Oregon, a virtual trade ally summit. That's a virtual meeting. If you are interested, that's on our Eventbrite page and live now. You can sign up for that. That'll be Wednesday morning. We also will be hosting our first in-person event, which I'm super excited about, on August 13th. That's our summer contractor member event. If you have not signed up for that, please do so. And then this is more of a save the date because the event isn't live yet, but September 23rd, we will be talking about government contracts. We'll have folks from GCAP and PTAC telling us a little bit more about what it takes to get those contracts, the government, and that will be a virtual training in September. So all the ways you can connect with our office. If you don't follow us on social media or you're not connected to our YouTube channel, definitely do so. All that information I have there. And with that, we wrap up. So thank you so much, everyone. And we'll see you at the next training. Bye.
Thanks all. Bye.
Guys.